Welcome to this episode of the Justice Team podcast on the Justice Team Network. We give practical how-tos for lawyers and anybody else that wants to learn. I'm your host, Bob Simon, and today we're talking about trial work, trial practice with the Lourdes DeArmas.
Hello.
How are you doing?
I'm doing great. How are you?
Well to quite well. And first, congratulations on another multi-million-dollar verdict.
Thank you.
And also moving up the chain in ABOTA.
Yes.
So can you
One more level.
And that's ABOTA.
Yes, it is.
And can you tell everybody what that is?
It's the American Board of Trial Attorneys, I think.
Advocates, maybe.
Advocates.
But it doesn't matter.
And it's very difficult to get into. You have to have a minimum number of trials. It used to be 20 years ago. Then it went down to 10 trials as a first chair. And now it's 7, but you have to have 100 points total. So that could include other trials where you were second chair or criminal trials as well. But it has to be 100 points, 7 trials minimum to get in.
Yeah, and with ABOTA, there's criteria, but they also follow up. Like I remember when I did for my first application, you have to list every trial you had, who was the judge, opposing counsel, and they have to fact check it all.
They do. Not only, I'm on the membership committee, not only do we fact check it, but we talk to every opposing counsel and ask how civil you are.
How civil, yep. Important.
And what they remember. And people that don't get in, it's usually because they were assholes. Mm-hmm. And it's part of their personality and how they treat everybody around them. And it matters. I mean, it doesn't mean that you can't advocate for your client and you can't take a position to further your case, but there's a difference between being uncivil. And I think some people cross the line.
And also unethical. We were talking off air about, some firms that deliberately hide evidence and they've gotten terminating sanctions. We see that more times than we should, but that's a point where you would, no matter how many trials you would have or your success, you would never get into this organization.
No, never. Not at all.
So, if you're watching or listening, I always think whenever somebody says that they're a trial lawyer, ask if they are in ABOTA, because I think that's like the hallmark of being a very good lawyer in person.
I think so too. And I've noticed that opposing counsel, I usually jump in cases for trial only. So I get it 100 days before trial, sometimes a little less, but always when expert depositions start. And the respect and tenor of the opposing counsel completely changes from the associate that was working on it to how they treat me because I'm in ABOTA. It shouldn't be that way.
But it is.
But it is.
And
even the judges.
The judges, if they know you're in ABOTA, they just give you more credence.
They do. They do.
Because sometimes, a lot of times, actually, a lawyer in ABOTA has tried more cases than that judge.
Definitely. And then I moved up a level. So to get in, it's about 10. To move up a level, I think it's 20. I have 28 right now as first chair, 50 total, including the second chair trials I've done. So I've been around the block a little bit.
I'm still at the first level, even though that I've tried like 50. I just never done my renewal to level up.
The good thing, though, is that the level up is on, you don't have to put every trial you've done. You just have to fill the application and say the number of trials because it's on the honor system.
Oh, maybe that'll be easier for me. It's
Yes.
just like a time thing. Okay, well, let's go off that tangent. Well, first, before, ABOTA, when I first joined, I think was one of the youngest ones to get in, and then one of my partners beat me. It was like all guys, and mostly all guys in like their 70s. It's changed in the past 5 years-ish.
It's changed a little bit. I think I'm also on the board of ABOTA National, and the numbers from ABOTA National is our average age of the membership is 68 years old.
Ooh, the average age is 68?
Average age. And I think women are still between 15 and 20% of the membership.
Wow.
Los Angeles ABOTA, we've made a big push at getting more women to actually apply. There's a lot of women that have the criteria to apply, but then didn't feel that they were welcome or it's an organization's for them. So we have a subcommittee in ABOTA Los Angeles called WOBOTA, which is the Women of ABOTA. And we've been more inclusive, having events and reaching out to younger women attorneys that are either at the cusp or have qualified to push them to join. And when I first got appointed to the executive board of LA ABOTA by Schoenbuck when he was president, I was one of 5 women on that executive committee of about 40 people. And now there are significantly more women. Still not enough. It's not even close to 50-50. The board isn't even 50-50 plaintiff's defense, but we're getting there.
Yeah, and an important distinction, it is plaintiff and defense, so it's
Yes.
any trial lawyer. I find that, like, all my best friends are trial lawyers. Are you the same?
Yes, yeah.
I mean, it's like, it's kind of a sickness, but that's your crowd. So anybody watching or listening, if you want to get into it or you're close, surround yourself with this because it's a constant think tank. All right, back to the recent trial that you had and the ones in general. I know you do very well at picking juries.
Yes.
And we've been on the Justice Team podcast. I was listening to an old episode we did a few years ago. Things you said then still hold true. So tell me, are there your general philosophy with jury selection, how you applied it into this trial, and some things that you think worked very well?
This trial was difficult for me, primarily because the judge wanted to give us 30 minutes to question a panel of 27. And the judge in particular, he does an hour of questioning the jury, which is not really as complete as he thinks it is. So I actually, for the first time, used a jury consultant, which I never did before, but because I knew that there would be time restraints. But the judge also said that if I was being productive, he would give me more time. And so going in, I knew that I was strapped for time, which was new to me. I did not feel that at the beginning when I was asking questions, I was at my best. But then as it got more into just focusing on what I was doing and not the time restraints, I ended up asking 2 questions to every single juror. One was on liability because we had a liability issue. It was more, about responsibility.
Yep.
And the second one was, are you willing to give millions for pain and suffering? And that second question was where I got the most
negative
response. 3 jurors screamed at me.
And that's good. You want to embrace the hate. You got to embrace it. And
I
know the venue you were in, and I'm not surprised that you were getting that.
It was hateful. But then I reverted back, to just custom and practice and how I always have picked a jury where I just hone in on the person and I talk to them and I ask them and I let them yell at me. And I ask them, well, tell me more. I want to hear more about why you feel that way. And I have never really said, raise your hand and tell me who feels this way, because first of all, I can't keep track of everybody. And second, for me, it doesn't work. I think it's easy for people not to raise their hand thinking that you're not going to talk to them. So I really do try to talk to every single person in the room. And I think at the end of the day, it was a horrible jurisdiction. By lunch, and by the way, the judge wanted a jury picked by 12, by lunchtime. I was not through.
Why speed up the process? It's the most important part of
it. Was. I was only to juror 12 at lunch. And I took the whole day. He didn't constrain me to the 30 minutes because he saw I was being productive.
And that's the thing is judges always will say they'll have the time constraint. Sometimes they'll say, and if I'm seeing you be unproductive, it'll be less. But if you are productive, if you're asking open-ended questions, letting the jury talk rather than lecture them about the case, a lot of judges will give you leeway.
They do. And that's the key, what you just said. A lot of attorneys want to hear themselves talk because they went to some seminar that says that, you have to show the jurors that you're in charge and your rapport and get them to like you. I don't care at that point if they like me. I want to know who is going to fuck my client, sorry to use that term, in the back when they're deliberating, and I want to get them off. And that's my sole goal.
It's jury selection.
Yes.
Find the poison, get it out.
That's it.
And
That's
find a
all
way
I
if it's
focus
for
on.
cause, which the judge can kick them off, so you don't have to burn what's called a peremptory, which is you get X amount, depending on your jurisdiction, to kick for whatever reason. But it's free if the judge can just say, you're so unqualified and biased, you're out.
Yeah, 100%. And we had some attorneys come and watch. You have that when you try cases too. And a few of them came up to me at one of the breaks and they're like, well, do you know who the leader is of your jury? Do you know who this is? Who's a follower? I was like, I don't even think about that. I just hone in on who do I need to get out. Yeah. And that judge in particular said that the most for cause challenges he grants is 3. We got 12.
Wow.
Which he says was the most
awesome.
He's ever had granted.
Well, now thank you for changing the judge's thought process, and should be easy for the rest of us when we go into that courtroom. How I always try cases with jury consultants, by the way, just because I always like a second set of eyes because I don't take notes. I'm in the moment. Same thing when I do ask for a show. Who agrees with so and so? I'm not keeping track of that. Somebody else is, and writing those critical questions. Do you think it was helpful for this trial?
It was incredibly helpful, and I learned 2 lessons. One was, the jury consultant wrote out the questions I needed to ask. And the mistake I made was asking the question exactly like they wrote it because it wasn't authentic to how I speak. So now I know when I use them again, or any jury consultant, yes, the questions that they gave me were what I needed to ask, but you need to change it to what's authentic to you and the way you speak, because I couldn't sell the question and I struggled at the beginning. The second thing that was helpful is that they wrote down, or she wrote down, it was Claire Plotkin.
Oh, I love Claire.
She was amazing. By the time we went to argue for cause, she wrote down exactly what I needed.
Yes.
Exactly.
That's why I love her. Claire and Harry Plotkin. I picked juries with both of them.
Phenomenal.
They'll write exactly what you need to tell the judge to get them off. Quotes and everything.
Exactly. Phenomenal. And then there was times, because we knew we were on time constraints, she would hand me Post-its and, we had a synergy. Like, tell me when I need to move on and I've gotten enough. Or tell me that I need to continue digging further. And so she would hand me Post-its like, you can move on, we've got enough. Or you need to dig a little further. There's a doctor in the back that we haven't gotten to. Ask him X, Y, and Z, which made it more seamless and incredibly helpful.
I love it. And I've been talking to them about creating an AI platform, kind of using the brain of the Plotkins, but researching. The hardest thing to do is, where we try cases, you get handed the sheet of the jurors when they walk in.
Yes.
You're literally writing notes about what their names are and stuff. In some jurisdictions, they give them to you like a week ahead of time. We don't get that luxury.
No, we don't.
So how can you quickly pull all the data? Because we have people back in the office trying to find their social medias, all these things. Like, I want to find a way to get all that information right away.
That would be amazing, because we do have our marketing team. I didn't do it in this trial because we had Claire, but in the other trials that we've done, we have a marketing team that's ready to go. We take a picture of who the jurors are, and within an hour, we have a breakdown of all of their social media, if they have it.
Correct.
Right? And the ones that don't have it are even more suspect.
I know they're hard to find. Usually not good jurors.
No.
Whatever, if they're hiding. So jury selection, once you pick those 12, and from what I've heard, it's the defense lawyer thinks that they're winning because they heard so much bad things during jury selection, which is not true because they got kicked off. So now you're getting to opening. So what part of the trials did you handle in this case?
I did jury selection and closing and rebuttal. And then I did the liability witnesses for the most part, and handled some of the experts, although it changed the strategy, right? Coming into the trial, it was supposed to be me and another attorney. And then we added Ashley. And so Ashley's focus was going to be...
That's Ashley Lakin.
Ashley Lakin. Okay. Her focus was exclusively the client, because we knew that the client was going to be an issue. But then the trial ended up just being Ashley and I, so we had to redivide and rechange the strategy of the...
Do you like trying cases with partners?
I do. Yeah. I do. I think that, especially Ashley, right? We have a synergy and chemistry that I haven't really found with other people that I've tried cases with. And I've tried cases with Chris Dolan, love you, Chris, and Mike Alder, but it's not the same like it is with Ashley and I. And it works, I think, because it alleviates some of the pressure and you can hyper-focus on what you need to do.
Yeah, because stress can absolutely cripple you in trial if you're trying to do too much and you want to take on too much. It just doesn't work.
The exhaustion level of it. And I over-prepare. I'm not one to wing it. And what Ashley and I do, and what I think most attorneys should do, especially if you're new to trying cases, is we look at the trial holistically. So from opening to closing, what is that we're trying to prove? What is our strong points? What are the negatives? And what do we need to accomplish with each witness that moves into the next witness? So we're not looking at each witness individually. We're looking at, I need this from, for example, the PMK of MTA that's going to lead to what I need with the driver on the stand, that's going to feed into what I need with my bus expert who's coming next. And sometimes it doesn't work that you get them in that order, but we did. And then we take damages. So that was liability. We're done. Then we look at damages. What depositions have we taken? of treaters. I take a lot of treater depots.
Same.
And have them in the can. And then then the surgeon comes in. I never have my treating doctors as my experts ever.
Agreed. Actually, I have a big, like the book that I wrote about trying disc injury cases. I talk about exactly that.
I ordered it. I haven't gotten it yet.
Dude, what happened is there were so many orders, they couldn't print enough of them. So they released the E1 now, so you could get electronically. But yeah, I agree 100% with that. Have a third-party expert, your treater, stay the treater lane, videotape as many treaters that are helpful as possible for trial. Because you go in with control. You can win your case by just playing videotape if you wanted to.
Yes, 100%. The only depot that I don't take is the main surgeon that I'm going to bring at trial. But what we did in this trial that we just did, which I thought was effective, we did not know how our client was going to present. And you never know, because they could give you a great story when you're prepping them and then clam up on the stand.
The two hardest part of trial, jury selection, director plaintiff.
100%.
That's where you win or lose your cases.
And I never do the direct of our client.
I try not to these days anyway.
So what I did with the treater depots is I asked the treaters about my client's damages. All said he was a nice guy. All said that he was genuinely injured. All felt sorry that he was a 27-year-old that can never walk normally again. In closing, I ended closing with a clip of his physical therapist.
Oh, wow.
And the clip basically said, he's a 27-year-old that will never be able to do things that other 27-year-olds can do. He's 31 at the time of trial, and he will never walk normal again. And that's how I ended my closing.
Wow.
So we used the treaters to develop the damage story.
Very important. And I like to also use the defense experts to do the damages story, because it's like, you saw him on this date. Tell this jury what the plaintiff, my client, told you was going on in their life, and they just read it.
Oh, that's good.
And it's so like, I tried to build another damages touch point in the expert. Say now, and all that stuff. Are you telling this jury that if this crash never happened, that they'd be experiencing all these things? Oh no, I couldn't say that. Well, can you tell this jury that, like, if this crash never happened, that they'd be dealing with like depression, not being able to walk, and it just I'm good the damage layer, and it's
tell me more.
Oh, and when you examined my client, you didn't think that they were being untruthful, did you? No, in fact, you thought there's nothing in your report indicating they were like lying or amplifying their system or their symptoms. No, I didn't see any of that. It's just like, thank you, doctor.
I love that.
No, but like we try cases very similar to you and I, because I know the things that we like to do. Are you mindful during trial about your audience of 12?
Yes.
How so?
In how they're reacting, if they're bored. I have a trial paralegal that goes with me to every trial, and her job, aside from getting things filed that need to get filed in the everyday things, is that she's taking notes on all the jurors. Who's falling asleep, who's taking notes, their reactions. We had, obviously video, which you don't normally have, of our client actually getting hit by a car, and their reaction to that, who didn't, who did. And then, every time we talked about it and clips were played, we were very cognizant of their reactions to it and not to overplay the clips of our client getting hit. So when we needed to show a clip, we would stop just short of him getting hit again, because we were making the point of the video before that, and just how they were reacting to it, because by closing, you don't want them so desensitized to the horrible nature of the accident that they don't care anymore.
Yeah, that's a good point. And did you, since there was a liability dispute in this case, jury didn't buy any of what the defense was selling?
Not at all.
Zero.
Oh
boy.
Zero.
So whenever you have no one's very unlikely that you have your crash caught on video or whatever it may be. Nowadays it might be a little easier with technology. When you have that moment, did you focus group at all? Did you run it by people to see what their thoughts were on liability just watching the video?
We did. Harry did 3 focus groups for us, and he did online, which I've never done online before. I like the in-person talking to them, but it became very effective because he did 3 within the span of a couple hours. And we didn't know whether we showed the video at the beginning or waited until some of the evidence and showed it with our expert. And so we tried all the different ways. And when we showed the video from opening, the jurors were 100% on our side.
Yes. Yeah.
0 comparative on our client. And when we showed the video later on, then there was comparative on our client.
Wow.
So I think that that's very key, because in the order of the evidence becomes important in that regard. Like, when do you show it? When do you play it? How much do you play? All of that became important.
Yeah, and there's this one company called Emotion Track AI. I don't know if you know them, but they put it in front of so many different audiences that they let you watch the video and you could see like the reactions emotionally of the content and see how they feel about it. And then also you could do your opening statement in PowerPoint and then use the video and track the emotions of everybody to see. It's like those focus groups where people push buttons and see how they're feeling but on like a huge scale.
Love that.
Yeah. We started doing it. It's really cool.
That is really cool. One of the things that I think Ashley Lakin and I did that we don't know if a lot of attorneys would have done it. Maybe you, obviously, because we're a lot similar, is that nobody looked at the video, not even defense attorney, from beginning to end. It was a bus case, and there's 8 different cameras, and it captured about an hour's worth of time. Okay. And nobody looked at the video till the end, right? Because they were claiming that the car, so the door's open, my client steps out in the middle of the street and gets hit by a car. And the police report said it was a hit and run. So defense, part of the liability dispute was that our client should have looked both ways before stepping out, and that other car was a hit and run, was liable, and MTA was not. So Ashley and I actually sat there and looked at every angle, every video from the end, and we noticed that the hit and run driver pulled the car around into the mini mart, got out on his phone, and walked to the corner where my client was. And then we looked at the different angle. The bus driver parked the bus across the street, walked over, and you can still see the car and the man at the corner. Right? But by the time we got it, we couldn't get the 911 tapes because I will bet you that guy was on the phone with 911. And we couldn't find him to depose him. And so on the stand with the driver, I said, what happened to the other driver? And he said, oh, he left. How do you know he left? Because he made a right-hand turn and drove off. And then I was like, okay, well, let me, we had Gordon from Reikio. And I said, Gordon, can you play video number?
Oh, Gordon's awesome.
Yeah, he's amazing.
Yeah, Rakico service, by the way. We use him for every trial. Dave Racky and his team. Gordon's awesome.
Right, he was amazing. Oh, yeah. And so we played it, and the driver was like, I've never seen this before. So I guess it wasn't a hit and run. The other thing that we had saved.
Did you call him first?
No, we called him second. We did the PMK first to establish all of the policies that he didn't.
That he later broke.
That he broke. And then, but we also had prepared, because we looked at it, we looked at the 911, not the 911, we looked at the first responders. When did the first responders arrive?
Oh, you timestamp.
Timestamp. So the first responders arrived 7 minutes after the accident and were on the way to the hospital within 15. The police did not arrive until an hour later. So the argument that I had ready to make that I didn't have to make is that the hit and run driver wasn't hit and run. He stopped, he called 911, he was there, but because he wasn't there at the time that the police report doesn't make it a hit and run. Defense wasn't ready for that because nobody looked at the video to the end.
Yeah, I love it because I overanalyze some of those videos and looking at every different angle, because sometimes you could see how many, was there a car there? Could I see headlights there? Like this whole, I had a visibility trial once recently. Anyway, God, we could talk for hours.
I know,
we're
we
almost
can't.
At the end of the show here. Jeez.
Because one more thing that we did, and Ashley caught on to that, is how do we argue that our client should have looked both ways when he stepped out? So Ashley did a compilation of every single person that got off the bus on that video that didn't look both ways, and we played it for the jury.
Okay, now think logically. I think that's fantastic. Think logically. Nobody stops at the end of the bus, looks both ways, and gets out. That just doesn't happen. You just walk off the bus.
But we had a lot of the jurors during jury selection that said he should have looked both ways. So we had to think, how do you combat that? So we did a compilation.
I love it.
Yeah.
I love it. Lourdes, how do people find you?
They could call me on my cell.
Wow, here we go. Let's go. Write it down.
Which is 310-424-0449, or email me, lda@omegalaw.com.
lda@omegalaw.com. Lourdes, thank you for coming on. I'm a big fan of yours, as you probably know.
I'm a fan of yours.
Reach out to Justice Team Network, just the Justice Team podcast. Go to justiceteamnetwork.com or YouTube or wherever you're listening or hanging out. But look for an old episode. If you go through the old Justice Team podcast, probably 5 or 6 years ago, Lourdes has probably been on a couple, but we had a good one about jury selection that a lot of those things still hold true. But thank you for watching and listening to this episode of the Justice Team podcast.
Thank you for having me.